So my attorney just filed a pretrial conference for me. What is that?
A request for a pretrial conference is a very normal and very customary thing that we do here in family law. At its simplest form, we're just asking the court to give us a date so that we can present ourselves either to the judge or the court coordinator to set a trial date.
Okay. Do I have to be there?
It depends. If we're in Tarrant County, there are a handful of courts that do not require the client's presence at a pretrial conference. Those courts include the 231st, the 322nd, the 324th, and the 360th. However, the 233rd and the 325th do require a client's presence.
What if I forget to show up?
More often than not showing up at a pretrial conference is going to be okay. If you are represented by Varghese Summersett, you will have ample notice that a pretrial conference is pending and that your presence is required. However, if you don't appear, a judge is not going to cancel the pretrial conference date. You are not going to be defaulted in any way by the judge. In the courts, in the 233rd District and the 325th District Court, in which the judges do require the clients to be present, the judges just like to put eyes on the client. They like to familiarize themselves with the clients and the parties and really explain to them the implications of trial and encourage settlement to the extent that settlement is possible, and just really kind of give you a holistic understanding of what is happening at trial and the fact that when you do go to trial, you are effectively turning your case over to the judges to make all of the requisite decisions that need to be made in your case.
Okay, I think that makes sense. So you said that they set a final trial date. Are there any other deadlines or dates that are set?
Much to the chagrin of many attorneys, yes. Every single time a trial is set, there are 100 different deadlines that have to be followed. Probably the most significant for many parties would be the mediation deadline. So the average court, including every single court in Tarrant County, absent good reason, mandates mediation in every family law case. The reason behind that is because family law judges really want you and your co-parent, your spouse, to try to work things out amongst yourselves before you get to trial. Because as I mentioned, once you do get to trial, you have one shot to present all of your evidence and to have the judge make a ruling on everything. A lot of people are just really not comfortable leaving everything up to one arbiter. That's their job. That's what they're elected or appointed to do. But it's really difficult for a judge to get the full picture. And many judges will tell you they don't know your children the way that you know your children. They don't know your circumstances or your situation the way that you know your circumstances and your situation. And it's not always easy to get all of that information across in a day, or even 2-day trial. And so mediation deadline is definitely something that is going to be very important. And once we do get that trial date, we will get mediation scheduled per the deadline as quickly as possible to maximize your chances at walking away from your case with a settlement that hopefully is mutually agreeable, or at the very least, a decision that you feel as though you've had agency in. Other deadlines include, in divorce cases, deadlines to exchange what are called inventory and appraisements, which are just a long list of all of the assets and liabilities that are owned by you and your spouse. Deadlines to exchange exhibit lists. So should you have to go to trial, providing the other side with all of the information that you intend to use at trial. Discovery deadlines. So when does discovery need to be served and received by? Deadlines to designate expert witnesses to the extent that you have perhaps a therapist or CPS or even your attorney to testify as to attorney's fees involved. Your typical pretrial scheduling order is probably going to have a lot of information, a lot of deadlines that perhaps is not relevant to the average client or the average party, but it definitely are deadlines that your attorney is going to be paying very close attention to make sure that should we have to go to trial, can have all of the information and can utilize all of the information that we have to the best of our abilities.
Yeah. Those deadlines sound a little overwhelming. Am I responsible for any of those?
You will be responsible for the information for some of them. And to the extent that you are, you will always be contacted by our office with ample time before any deadline for us to get, for example, an updated statement from you as to current values of bank accounts, retirement accounts, things like that. As far as exchanging evidence or discovery, these are also pretty important deadlines. So to the extent that either we are sending out discovery requests so we are asking for information from the other side, or we receive discovery requests, so the other side is asking for information from us, it's really important to comply with those deadlines. More often than not, when we're served or we are serving discovery requests, the deadline is 30 days from the date of receipt of that request. So as soon as we get discovery requests from the other side, we will always share them with you. And then it is incumbent upon you to read those requests and try to provide as much documentation as you possibly can provide. Of course, you're not going to have necessarily everything that they're asking for, but to the extent that any client, any party has questions, that's exactly what we at Varghese Summersett are here for.
What if I, as the client, don't provide all of my information or I cause you to miss a deadline?
That's a really great question. So if information is requested from us and there's a world in which that information can be produced. If it is not, then the other side can file what's called a motion to compel. Motions to compel are nothing to be scared of, but it is a formal request from the other side to the judge to force you, essentially, to provide the information that it seems like you are unwilling to provide. Inability to provide that information is one thing. If you don't have the information, of course, there's no information to provide. So motions to compel are typically only filed in cases where one side knows that the information is out there and it just seems like the other party is deliberately not complying with the discovery request. In the event that a motion to compel is filed, that party, the party filing it, can also request attorney's fees, which is always frustrating. But in cases where motions to compel are filed, attorney's fees are typically awarded because the motion wouldn't have had to have been filed if the discovery requests had been complied with in the first place.
Oh, that makes sense. I want to make sure I do everything not to have to pay their attorney's fees, so I'll make sure to provide all of my information.
And that is exactly what we're hoping for.
We hope this video has been knowledgeable and helpful to you. If you have any other questions, please feel free to reach out to us.